Good evening. I'm Wilson Hune. Welcome to our program on the 5 types of legal argument. I've been a professor at the University of Akron School of Law for 30 years. And during that time, I've taught a lot of different courses. And I have found a pattern that exists throughout the law. In law, there are 5 types of legal arguments. I wanted to share this theory with you through this series of programs. In teaching constitutional law in particular, this pattern has been very significant, but I reiterate, this pattern occurs over all areas of law, every discipline of law that I've had the privilege of teaching. We see the same pattern, but what is that pattern, and what is it that generated the theory of the 5 types of legal argument? Well, you know that the Supreme Court of the United States has handed down a lot of decisions, a lot of very difficult decisions, by 5 to 4 votes, and I've listed a few of them here. In 2003, in McConnell versus Federal Election Commission, the United States Supreme Court said that campaign finance reform and limits on contributions by corporations, for example, were constitutional, that those laws were consistent with the First Amendment. But a few years later, in the Citizens United case, which I'm sure you've heard of, the Supreme Court said that certain limitations on the ability of corporations to spend money on political campaigns, that certain of those limitations were unconstitutional. Again, by a 5 to 4 vote. But it raises the question, how is it possible that people who are as intelligent and dedicated and loyal to the Constitution and principled people with integrity who believe in the law and they're committed to the rule of law, how can these people come to different conclusions about what the law is?